Here at the studio. We didn't come to the studio to do the program on the 25th because of the holiday, and that is a holiday, the Holy Day. The country's maybe the second biggest holiday the country has. I don't think anything is bigger than what they do on Thanksgiving. I don't see any parades out there today on the 20. I didn't see any parades on the 25th of this month. But Thanksgiving, you see Macy's and all of that, and a lot of celebrations that go on around the country. And I think that will be the biggest holiday. The family gets together and people give thanks for the country they're living in and those kinds of things. And that's very important. Family comes together, and we can now meet again on Thanksgiving because they have given us the approval. Because they are no longer saying we have to stay away from our family members. COVID's going to kill us if we go over to grandma's house and have turkey and dressing. Grandma's going to fall over and die. That's if we don't push over the cliff first. So we got past that. But this holiday we closed down. We very seldom close down the studio on any day unless there's an emergency. And we try to be consistent in our airing of the program because I know that our viewers expect to have a weekly program here. And there's some great programs here. I was watching one of the programs by they have a ministerial program on the network. It's a very good program. And they had a very interesting guest on, I think it was last week. So we're going to try to at least be equivalent on that level today. We're going to be talking about the Supreme Court getting it right. They had a ruling which reminded me of the fact that every once in a while the case is so egregious and it is so clear what the constitutional mandates are that the court can have unanimous verdict. This is not very often the case. And when it's been the case in some situations, like in the Brown versus Board of Education case of 1954, it was because of a lot of politicking that went on behind the scenes. And the justices had a number of meetings about how they're going to approach this situation because they had to deal with a couple of problems here. And that was the South was ready for a fight. And if there was any wiggle room in the court's decree, then they would take that wiggle room probably and run with it as to say that the court was not, in fact, unanimous in its judgment. So therefore, the division of the court shows then that there is many on one side of it as another. And if it had been like 5-4, they would have had a very good case to make. They were out there deliberating before they went and made their ruling in Brown. They had predetermined before even having heard the case, quite frankly. Well, they'd heard some of it before Earl Warren became the Chief Justice of the Supreme Court. And they had heard that under, and I do have the name finally correct after misstating who was the Chief Justice of the Supreme Court prior to Earl Warren becoming the Chief Justice in 1954. Fred Vinson was the Chief Justice of the Supreme Court prior to that, but he had had a heart attack and died. And anyway, the court was unanimous in terms of overruling Plessy versus Ferguson in 1896 in the what became infamous, but was not infamous at the time of the ruling, but in the infamous 58 years later of the separate but equal court ruling that the court made, that equality is a standard, and if you can make separate equal, then the standard is equality. As long as the separate schools were equal to each other, it was not a violation of the 14th Amendment of the Constitution. But rarely has a court had that kind of clarity where the court can be unanimous in terms of ruling. It's really problematical to me. I think I'm bragging here, I guess, but I don't see too many scholars out here, quite frankly, that are on the level that I think that I'm on, or have the training that I know that I have. And I have to be honest and say that because I listen to them and I get very frustrated in some of the things they're talking about and misstating the document, getting the statutes wrong, a lot of confusion about what the statutes mean, and yet the meaning should be clear if you had any training as they claim to have. And I was very frustrated until I began to understand what the problem was. Most of these people are not really trained in the Constitution. They're trained lawyers, and that's a whole different level of training. But the court did have a 9-0 ruling in 1954. And recently, I was very elated to see that the court was unanimous in the ruling against Jack Smith. Jack Smith this is my interpretation of the role he's playing. Jack Smith is an attack dog. He's not even trying to follow the letter of the law or any of the strictures in the constitutional dogma. He's not trying to follow the Constitution. This man is trying to get Donald Trump, and that's why they put him there in order to because they cannot stop Donald Trump this time. You can see the handwriting on the wall. Whenever you have New York asking for Trump to visit there, not to bypass them in terms of holding these rallies, when they're saying that in Manhattan, and Manhattan is where Bragg's is in terms of one of the court cases against Donald Trump, when they're in that backyard asking for a visit from the former president, the 45th president, then that's something of circumstances very serious. And just shows you the winds are beginning to turn. And I'm very optimistic about it, as I was very optimistic when the Supreme Court came down in a 9-0 ruling. Very rarely it does this, but came down in a 9-0 ruling where the court was unanimous in terms of they're not going to allow this case that Jack Smith has against Donald Trump. They're not going to allow this case to be heard on an expedited basis. In other words, you jump ahead where it doesn't go up through the appeals process, but you take it directly to the court. And here's why I had predicted that there was no wiggle room here, because I understand that what Article 3 states. And the Supreme Court, if it were not this, it would be a court that would be flooded with, it's only a single court, so it'd be flooded with all kinds of cases if it were not an appellate court, the ultimate appellate court. And you go into a number of other courts before it gets there, and the ultimate determinant of what the Constitution requires is the Supreme Court. It's supreme because it's the ultimate voice in the judicial system. It's the only court really that is set up by the Constitution. The lesser court set up by the Congress. But I had said in my articles on Facebook, and nobody is writing. I'm going to give myself another shout out here. I think I deserve it. I'll toot my own horn. Nobody else is tooting my horn. Everybody's out here pointing their fingers at me. So if I'm having horn tooting in my favor, I got to be the tutor. So I'm tooting my own horn, I guess. But I have to tell you something. This stuff has got to stop. These people are talking about. But I had predicted that this ruling by the court would be that Jack Smith would not be allowed to expedite his case against Donald Trump by cutting off all of the circuitous routes through the appellate process to the Supreme Court and make a preemptive ruling. And then after having done that, they would have clear sailing to go after him with the things they're trying to contend. And I know that what they're contending is really unconstitutional. I don't know if anybody else is saying this, but you really cannot bring a president to trial after he leaves office for what he did as president. There is now, because nobody is above the law, and the president can be brought to heel based upon the law, but there are certain procedures in place for the president because of the stature of the position that he has as a custodian of the and embodiment of all of the people in the country. All the citizenship is embodied in the president of the United States by the fact that he's a single office holder in the country that everybody in this country votes for if they are a voter. You don't have that for any other office holder. This presidency is special. And it's special because it is part of the three branches of government in which there is a line of demarcation between the allocation of their powers, with separate powers in each of the corridors of the three branches of the government. And each one, in the very beginning of Article 1, Article 2, and Article 3, the very first words in it, it lays out what they are, in fact, being called to do in the separation of powers, and that is to say that the executive branch of government is there to enforce the law. It's not the job of the judicial, is not the job of the judicial branch of government that's established in Article 3, and that job is to, in fact, interpret the law in case there's any dispute that goes on among any of his members, or anything that goes on in terms of any dispute that goes on between states and other states. It comes in as a referee and can cut the difference based upon what the Constitution requires in those cases. His role is basically appellate, but it does make some exceptions to it, and the exceptions to that in this case right here are in fact spelled out in Article 3. That's why you could predict what the court was going to. I knew the court was going to decide that they would not hear the case. I was hoping it would be unanimous. And I had said that if it's not unanimous, then those judges that would vote otherwise would have lost all credibility for the rest of the time they'd be on the court, because the clarity of what they should have done is really clear by Article 3. Let me read this to you. The framers. This is what the framers put in place in terms of putting in an inordinate amount of time on the separation. They're ready laid to put to bed Article 1, where they spent a lot of time on Article 1, and they put a lot of time into putting to bed Article 2 as well. Put a lot of time into it because there was a dispute on the floor. Well, there's a dispute on the floor in each one of those. The dispute in the Congress on the floor was, is it going to be unicameral as it was under the Articles, or was it going to be bicameral? And the Virginia plan, James Madison's idea, was that they would have two corridors of power in the legislative branch of government, one in the House of Representatives. That's what it is purported to be. And if it's the House of Representatives, then people have the right to be in the House on January the 6th, because it's the people's house. And if they're not in there tearing anything up and they're walking around in the house and things of that sort, and doing so peacefully, they had a right to be there. Now, when it's closed and you have to break in there to get in there, then that's the break-in is illegal. You can't do that. But in this case here, what was going on is that they opened the doors up and waved them in there, and that's going to be shown if Mike Thomas is true to what he said he's going to do. I'm waiting for you, Mike Thomas, to do what you said you're going to do. You said you're going to let us see those 40,000 hours of videotape on what happened January the 6th. And if you do that, you're going to show that that rioting that was going on by those plants, PLANTS, plants. They didn't plant anybody inside the. That's nobody said this. They didn't plant anybody inside of the inside of the halls of the Congress. They planted it outside. That's where the chaos was. And when they put those 40,000 hours of tapes there, you're going to see people walking through the Capitol building. Some of them, like the guy named Chancellor Sean, I think his name is Sean Chansley, the one with the horns. They picked out the one that would have the most ominous look and make him the fall guy, as if these guys are coming to Washington for terrorist reasons. And that's not what they were doing. That's not what they were there for. That violence on the outside, the FBI plants and those others that were planted inside that group. And Roy Higginson from Texas, you did a very good job in terms of interrogating Ray and asking Ray if there were any assets, FBI assets, in the midst of that crowd there. And Ray said that he could not discuss that. And Higginson said, why is the answer not no? Well, if he had said no, he would have been lying on the oath. And that would have been a problem, although it's not so much a problem today, because if you are a Democrat and you're lying on the oath, nobody's held to account for it. But if you're lying on the oath and you're a Republican or you're a conservative, you got tremendous problems on your hand. Anyway, the court did a phenomenal job. It wasn't a hard call, but the court did a phenomenal job. Anytime you get 9 people to agree on any issue, and each of them is wielding some power as a jurist that has the same standing on the court as others have, to get them to agree is a major, that's a major ruling. A 9-0 verdict means that the court, it really means the court is so offended by the case that it found it so egregious. And in Jack Smith's case, they're finding it so, what's the word here in terms of being put off?
Or you can talk about the Supreme Court justice that just recently was confirmed who would refuse to answer.
You're breaking up, John.
Yeah, she was. We're talking. You've also including the same Supreme Court that had this ridiculous recent addition who couldn't even say what a male or female was. So I mean, that's got to be telling right there. Do you think there was pressure put on? Say, come on, this is where we can't do this. I mean, because I just can't see why she would even. She had a vote on this. She had a say in it, and she even came up on the right side. So that is a miracle.
Yeah,
how stupid she seems to be.
Yeah, John. Whenever they have a 9-0 verdict, we should celebrate that, because the court really should have 9-0 rulings. You're looking at the same language, and if the language is clear as it is in the Constitution, there's no ambiguity. There's no ambiguity in the Constitution of the United States. The framers were speaking with a very clear voice, and they understood if they gave any wiggle room, politicians will take it and license themselves to go out of control. They were you have to understand what the Constitution is designed to do. It's designed to nail government down. And so that's why it says in every part of the Constitution, except one part, and that's Amendment 10, it says in every part of it, shall, because the government is being ordered. There's not maybe, there's not should, or I wish, we wish they would do this. The government is being ordered to maintain itself under the corridor of power, the ultimate power. And there's an allocation of power through the Constitution that's given to the federal government by the states. Understand that. The states are allocating power to the federal government through the establishment of the Constitution of the United States. And they were so much about the powers not going out of control that they divided the powers up between the 3 branches of government. And then in the very first part of each one of them, delegated what each branch was designed to do. So in Article 3, you can read this language. The judicial power of the United States shall be vested in one Supreme Court. There's not going to be confusion here, because if there's one Supreme Court, then the other courts will be inferior courts to the mandate in the Constitution. Listen to this part here. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, to my federal courts here, shall hold their offices doing good behavior and shall at stated times receive for their services a compensation which shall not be diminished during the continuance of office. This is part here, this is section 2. The judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, listen to this part here carefully. To all cases affecting ambassadors, other public ministers, and consuls. To all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming land under grants of different states, and between a state of the citizens of thereof and foreign states, citizens of subjects. Listen to this carefully. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So the 9-0 verdict against Jack Smith was really a smackdown, and it's a statement of the insult the court felt. When you get a 9-0 verdict, of course, it can be political too now, in terms of having the judges coming together to understand that they must have unanimity because of the problems we create otherwise. Don't forget, the court these are men on the court, just like it be men in the Congress. So they're not above the human factor. The human factor is that you get in here and you begin to feel your Cheerios, and you start thinking that you're going to exercise power here that's not allocated for you to exercise. And sometimes you get into that, and they have to pull back from that, and hopefully they'll be able to maintain a certain integrity on the court. They haven't always done it, and many times they've fallen very short of the mark. But whenever you have a 9-0 verdict, then you have to applaud that, because the fact of the matter is that they're all reading from the same document. And it's not the document's problem. It's not what Napolitano says here, he has a book called Constitutional Chaos. There's no chaos in the Constitution. The Constitution can speak with tremendous authority because it's the ultimate voice that is to be heard in the rendering of what the law is. It is a standard. And there's no other standard that stands beside it, because all the other courts are lesser courts, inferior courts that are set up by the Congress, not set up by the Constitution. The Constitution sets up the Supreme Court. The Congress sets up the inferior courts. Now, what they all have in common, and I'll go off the grid to say this, what they all have all the courts have in common is that they are federal. I'm talking about the federal courts. They're all federal courts, and they all are under the umbrella of what is mandated in Article 2, Section 4 of the Constitution, where it's talking about civil officers. You see, these are civil officers. Why are they civil officers? They're not elected by, they're not elected. Civil officers are not elected officers. And so these are appointed officers. What the federal judges have in common is that they're all appointed, and they're appointed by the President of the United States. All federal officers are appointed by the President. And if you understand the Constitution, you can see why then they disarrogated. Alan Dershowitz, you don't understand this. And you need to stop saying the things you're saying on national television. All the scholars need to stop this, saying that you need to have the particulars that are stated in Article 2, Section 4 as a way of bringing about impeachment. Where is that found in the document? Where is that found? You need to stop saying things like that, because what you're doing, well, you're not doing it in front of the layman, but you really are embarrassing yourself. And you can say that in front of the layman. You can't say that in front of me. I'm not a layman. And you're not going to say that without getting challenged on it. And you won't. And I said this in my post, that what Lawrence Tribe is saying, that Lawrence Tribe would not say that.
Okay.
So I was off the center.
It was off my fault.
Okay, I'm glad you did that, John. Thanks a lot for your attention to detail. These people here don't miss anything. These are people that are the parts of the staff here. These people are really something, and they never cease to amaze me. And there are not too many people on the planet who amaze me, but these people here in the studio are some exceptions to the rule. But you have to get this. You can say things out there to the layman. You cannot say these things to me. You can't say what Lawrence Tribe said, that nobody's been impeached until the impeachment goes before the Senate. You have to impeach in order to bring it to the Senate. But I have to tell you this also, and nobody's ever said this before, and I'm saying it. They better not try to challenge it publicly, or it's going to be it's going to get very bloody. I don't mean physically. So I'm talking about the acoustics of it, the verbiage that's involved in it, the asking for the proof of the claims that they make so openly on TV. Because I consider them to be TV constitutional scholars. These are TV scholars. You can say that out there in the general public, and the public will in fact buy it, because they don't have this. They don't have that training. They don't have the training that they have. But they don't have the training that I have. And that's why I call them out, because I know the training they have now. I couldn't understand why they were saying things they were saying. And I knew I knew they didn't have the training that I had, and I was trying to figure out why are they saying that. Then I had to, but I read this one who was that person that said that? What is his name? Anyway, he made a comment and said that his comment was that constitutional law has very little to do with the Constitution. That blew me for a loop. But then I began to understand that that's the problem.
See what it is we kept on a lot with this way. It's in local government too. They got the rules, and then they find somebody. They have to. Some situation comes in, and they have to try to push aside the rules or ignore the rules, and then they start setting. Even though they keep the rules on the book, it's been so used. This approach is used so often that's considered just the way things are run.
Yeah,
and it's just
John, that's a very good point there, because one of the biggest problems that we have with the court system is that they look at the precedents that have been set, and they try to look back to see what the court has said in the past in order to be consistent with it. But there are some things that are so egregious in what the court has said in the past that it cannot be sustained based upon the fact that the egregiousness of the ruling is so out of kilter with the times that you have to go back to the document and you have to get it straight the second time. The second time around is better sometimes than the first time. And the court has gotten a lot of things wrong and had to correct itself. Coming back to the original document and getting it, because you're not, can I say this about you getting mad? You really don't have any better expertise because you put a robe on. You can't be appointing people like this man just did in terms of Ketanji Brown Jackson being appointed because of her gender and because of her race. When you start doing stuff like that, I don't think I really think that should be impeached. See, they think that impeach means a trial. They think impeach means being subject to removal. That is not true. Nowhere is it stated in the Constitution. There doesn't even have to be a trial. I know the scholars are not going to accept that. I tell you what, they better not do. They better not challenge it publicly. I'm not here to play any games. What the framers wrote is what they wrote. They found that out in grad school. Some of the instructors, I give them a lot of credit, but they were not on this, they're not on this level either.
I guess question here, see what test here, kind of put you into an unfair test, I guess, but have you ever heard of a issue facing the country that the Supreme Court actually approached to say, we want to hear this case? They kind of did like engage in some form of activism, or because they're so desiring to make a ruling. Has that ever happened to your knowledge?
That hasn't, where the court will go out and seek a case. They can't do that. They can't go because that's an activist court. It's like, for example, it's clear that the cases against Donald Trump are unconstitutional. You can't do that to a former president, and you didn't go through the process to take down the barrier, the hedge around the president of the United States by the separation of powers, specifically Article 2. So if the court can't, it's wrong what they're doing, but the court can't go out there with no case put in front of it and then demand to hear the case because it is such an egregious violation of the Constitution and they're so offended by it, they're going to ask for this case, bring that case here, because then the court becomes an advocate. And how does it justify its ruling if it's an advocate before hearing the case? Can't do that. And so the answer to that question is that never has happened, and I hope it never does happen, because if the court does that, then its role as an independent arbiter that's not supposed to be siding with the plaintiffs or the defendant, if it begins to jump into it and want to just rule and things of that sort, that court is really out of control. I don't know how you'll be able to stand there again as an independent arbiter to hear both sides before you make a ruling. They have to bring the case to the court, is what I'm saying. And when the court then hears the case and hear the arguments, then the court can make a determination of how it's going to rule. But basically, they need to be looking at this document here before they do any of that. And I knew that they could not get 5 judges to say in what Jack Smith was doing, not with the clarity in Article 3. They couldn't get the 5 members of the court to say what he was trying to do, which is preempt the exceptions to the rule where the court ceases to be an appellate court in those specific areas that are itemized, listed, and enumerated in the Constitution of the United States, where it says these are the exceptions to the appellate jurisdiction of the court. These things can be heard directly by the court that has original jurisdiction. I was banking on that in terms of the majority saying that that case cannot be heard. What I wasn't banking on, but hoping for, that the verdict would be unanimous as a slap down, a smackdown of this man that needs to be smacked down, because this man doesn't have any, just by bringing that case to the court, this man has no respect for the Constitution of the United States. I don't think anybody, and this is just me going off the grid to say this, I don't think anybody in the Biden administration has respect for the rule of law in this country. Certainly have not shown any respect for the Constitution of the United States. And I would like to hear one of them come out and say what Donald Trump will say, and says with no compunction that he loves the country. Let me see if they would hug let me see if anybody in that administration would cajole the flag, the American flag. You think anybody in that administration? I'm talking about Biden too. Is he? You think he's a patriot? Ask yourself this question: why is Donald Trump getting so much animus? Outside of the fact, yeah, he's an outsider, hasn't held in a political office, so he's not one of them in that sense, who come up through the ranks, and then this guy jumps ahead of them and become the president. So that may cause some personality types of problems and things like that. So I may be mad about that. Didn't go through the process, didn't serve in the military, and didn't hold a political office. That never has happened before, and it's something new, and they resent that for that reason. But why would they be against MAGA? Why would they say that MAGA is a threat? And I keep hearing about a threat to democracy in the country. You know, people, these are comments that are outrageous. A threat to our democracy. You don't even have a democracy. A democracy is not even intended. You have Article 4, Section 4. You have every state is guaranteed in Article 4, Section 4, a Republican form of government. And I'm going to tell you this too, while I'm on that point. Yeah, you want to use Section 3 of Amendment 14. All you are saying that should be used as a way of driving Trump out because of the insurrection that you claim occurred on January the 6th. Let me tell you this. Until you repeal, this is Maul speaking, and there's nobody qualified to come behind and say anything different, and they will not say it different publicly. In order to put in the Constitution, Amendment 14, Section 3, you would have had to, first of all, repeal Article 4, Section 4 of the Constitution of the United States. Now, why is that? Because Article 4, Section 4 promises, guarantees, as a matter of fact, it says guarantees to each state a Republican form of government. And in the Republican form of government, the people have the right to choose their leaders. That's what Republican government is. And if you tell those Confederate officers that they cannot be elected by the people who chose them in those states to send them to Congress. They cannot do that. You've abrogated that document, and so does Section 3 of Amendment 14. None of you scholars are saying that because you don't know that. But if you go back and look at the only amendment placed in the Constitution by a different process than the process used in all the other 26 amendments, there's one amendment that's the exception to the rule, and it says in the proposal of it, it says that this amendment shall be added to the Constitution by a by voting convention. Conviction. I give my teeth in here, right? It is the only amendment in the Constitution where there is a ratification through a different process. The ratification was by 3/4 of the state conventions. And it says that in the proposal. Now, the other 26 amendments in the Constitution are all ratified through the same procedure, 2/3 proposal in the House, 2/3 proposal in the Senate, and then it's put to the states for the ratification by the state legislatures. But you see that the reason why there's an exception between 18 and 21 is because in the 18th Amendment, which is the abstinence lobby is so powerful. This is the politicians scratching each other's back to put that in the lap of politicians on the national level will put them behind the 8 ball and put them in jeopardy. So that amendment, in order to pass the amendment where, because nobody's following it anyway, in order to pass the amendment where selling, I would say homebrew in my neighborhood, because a lot of people were doing that, even though they had you had the right to buy intoxicating liquors and things that sort of that point. There were people that had an undercover. They had an underground. They had an underground economy in a lot of those neighborhoods in the South. In other words, a lot of people had distilleries. But if you think that was bad, look at the distilleries they had during the time of Al Capone, when nobody was following it. And if you cannot enforce the law, at least have enough integrity to then, since you can enforce it, unless you're putting all those persons up there in those hills in jail, then you have to be honest with yourself and then make the law congruent, at least in that case there, to the practice. People have the right to, people didn't have the constitutional right to do it, but if you're not harming anybody but yourself, then how do you make a law that prohibits someone from doing something that causes self-injury, but it doesn't cause injury to anyone else? Well, you say, well, if they drive drunk, that's the injury, yes, but the drunk driving is the injury. Being drunk is not, that's you over there in that ditch. But what happened in that case there is something that happened that's different than happened in all the other cases. In all the other amendments that were added to the Constitution, they were added there by 2/3 of the vote being the amendment being proposed in the House, 2/3. That'd be 290 in the House, and then proposed in the Senate. There'd be 6 or 7 in the Senate, and by being proposed, then the states are involved in it, in the ratification. You see, the states, you can't do anything about the states. That's the setup. That's the federal system that's set up by the framers. Look, you don't have that kind of intellectual wherewithal at any point beyond 1787. And I'd be darned if I'm gonna let lessers come behind that brilliance and take them down. You're not going to do that without being challenged. But you have to see, in order to add to the 21st Amendment, in 1933, you had to repeal the amendment that said otherwise. Listen carefully here. The 18th Amendment was a prohibition amendment. You can't have the Constitution contradicting itself and have in the same document a document that abrogates a part of the document, and therefore, before you could, what the 21st Amendment does is that it repeals Amendment 18. But you see, you have to understand how that happened. It happened because they knew that can you imagine what would happen if you have the abstinence lobby being as strong as it was at that time? People carrying signs around, the suffrage movement and people like that out there with signs. But they're also lobbying about a certain amount of, the Victorian type of thing here. And they had a strong lobby there. Can you imagine a politician standing up and voting for the continuation of drinking alcohol when there's a bill on the floor, an amendment in front of them to turn that back? How they would look like these persons are not moral and they're against morality in society and so on and so forth. They took it out of the hands of the state legislatures and put it in the hands of the convention so that the people would, in fact, decide. That's why that amendment is different from all the rest of them. But in the other 26 cases, all those amendments are passed through the same process.
It just dawns on you. We always get this myth that we are such a free country. But if you look at the European countries our ancestors fled, there was never a king or queen, actually, that I can recall in England or Europe or whatever, that actually forbade the drinking of alcohol. I'm serious.
Right.
And, when you look at the other things, the prohibitionist attitude we have towards, we are not a free country. Plus, we have the IRS, which can hold us even if we're not living here. They still expect us to cut them a check if we don't surrender our U.S. citizenship. So we are slaves in every sense of the word. Yet we have on a celebration. We have a 4th of July celebration. People shoot up billions of dollars worth of fireworks and wave flags that they want on purpose for celebrating freedom we no longer possess.
Well, John, I had to say wow to that because that really anticipates the article I wrote today, where I was talking about slavery. And I made the point that there was different kinds of slavery in this country. There's only one type of slavery that was in fact outlawed in this country. Slavery was not outlawed. I suggest you go read the 13th Amendment again, 1865.
Chattel slavery was outlawed, right?
Chattel slavery.
But we're chattel, but the way they engage us like that, it's no longer chattel.
Yeah, but let me tell you the kind of slavery you have here, where we're all in that net. Here's the slavery that you do have. See, here's let me say something here. This is why you basketball players, you multi-million-dollar, players while you're playing, this is why you're making your error. This is why you're going bankrupt after you stop playing the game. What your mistake is that you do not understand the different kinds of slavery they've had in history, in this country as well. You've had chattel slavery. Chattel slavery is outlawed. You can't have persons owning other people, but you still have debt slavery. And everyone, listen carefully here, everyone in America is in that net. I made a point today in my article, and nobody's going to contradict it. Not publicly, not going to do so. A lot of people disagree with me. They don't disagree with me in public. No scholars have disagreed with me in public. And there cannot be all this agreement out here now with what they're saying and what I'm saying, because a lot of it is 180 degrees removed to different ends. Over here, this is being said, over there, something else being said, and there's no congruency given the distance between the two claims that are being made here. And they cannot possibly agree with me what I hear them saying on television. But has any of them ever come out, although I'll call the names out and come out publicly and said their disagreements? No, debt slavery is, we all caught up in that net. And here's why we're caught up in it. Because nobody in this country can own anything, any property, land property. You can own gadgets, but Donald Trump, Oprah Winfrey, Money Mayweather, and the rest of them, they don't own any more than I own. The difference between me and Trump is that Trump is a debt slave on a higher level than I am on. He doesn't own any more than I own, except maybe some toys, like maybe he got more cars in his garage than I have at mine, and things like that. He doesn't own anything either. He doesn't own Mar-a-Lago. And that's true of everybody in this country. Oprah does not own that $90 million house she's in. Everybody is a debtor slave in this country. And that has not been outlawed. You don't make that payment when it's due, and they give you a deadline in which it's got to be in that office, being credited to your account. If that payment is not there, they take your property from you. And that's the freedom that is, in fact, denied and hidden from the people who think they're free, but they can take your property from you, and you can never own the property because it's taken from you in perpetuity as long as you, in fact, pay them to leave you alone. That's what the taxes are about. I was making this point today as well after listening to a tape that I was listening to, and the tape was making some very good points. It didn't make any points that were not made by Charles Adams. Charles Adams wrote brilliantly. He's not with us anymore. I think he might have deceased in 2016, somewhere around there. But Charles Adams wrote tremendous books about the taxation issue. There's no voice out there right now that can trump anything that he put down on paper. One of his masterpieces is those dirty, rotten taxes. And listen to that video today. I wrote one of my friends to send it to me, and I told him this. Given what that person said in that tape there, it's very clear from the implication of what he was saying here, is that the reason why this theft has become so much of a problem in this country, because taxation is theft. The reason why it has been so engorged in this country is because of the size of government. Therefore, the manifestation of the corruption in this country right now is seismic, and it's seismic because of the size of the government. Until the government is reduced, you're not even talking about reducing the corruption of these politicians and corruption in this country, because the behemoth they've created mandates corruption, and taxation is corruption if it's not for the reasons that are specified in the Constitution, which is the defense of the country, the operational things that have to go on here in terms of protecting the people in the country and maintaining public safety and securing them so that they're not injured by you have to have a police force, This idea of we're going to disincentivize and defund the police. You have to be, these people are mad. That the protection of the people against domestic and foreign danger is to secure the freedom of the people is a mandate. That's why you have government. If you have government has to serve the function of the security of the people. If it doesn't serve that function, there's no need for it. And so the taxation is what Ryan made this point. This is another point made by Ayn Rand. Ayn Rand made this point. It doesn't take a lot of money to run government if it does the function in which it's set up to do. But when it's out here engorging itself on all the things it shouldn't be doing, that's why I would say this as well, that I think that everybody talking about who's going to be Donald Trump's running mate. Well, my first choice, based upon the interview that she did a couple of weeks ago, it was done with Valuetainment. That's a great program. I think that guy's an Arab that does that program. I think he comes out of he's glad to be here because of I think it may be from Iran. Seems like he's
actually Patrick Bet-David.
Yeah, that's him. Yeah. What country you think?
Actually, his part is Syrian and his mother is Armenian.
Okay.
And he's actually, because of the church, that I tend to do the broadcast from. I got to kind of connect. I like to reach out to him, but he's very he's very intelligent on a lot of things. I mean, I disagree with a lot of other stuff though.
Yeah, but he's very intelligent, and he had on there. My second choice for VP, he had on there Candace Owens. And Candace Owens was making a point where, people say, well, giving all this money to foreign aid and things of that sort. And you say, well, that's not really appropriate to do that when your house not in order. And then they come back and say, well, you can walk and chew bubblegum at the same time. And she's making the point that apparently they cannot, because look at the infrastructure in this country right here. Look at our borders here. And if you can do both at the same time, make sure the borders in Ukraine are all right. And then look at our borders, the southern border of the United States. But it's not just the southern border, northern border is a problem too. But they come in from all sides. But if apparently she made this point in her talking on Valuetainment, apparently we can't do both. We can't walk and chew bubblegum at the same time because we're not doing it. Look at the tents out there in Los Angeles, our major city. Look at these people out there on the streets. You can give billions of dollars of foreign aid, and I said, look at that. Look at the clarity of this woman. She is clear on a lot of things. She make a very good vice president and take away the racial issue from Trump's adversaries. But my first choice, because I think that you have to first, my thing is that, have you been baptized by fire? I mean, God gave Noah the rainbow sign. No more water. The fire next time. And the person been tried by fire is Carrie Lake. That would be my number one choice. My number two choice would be Marjorie Taylor Greene. And that would take the sexism issue away. Either one of those persons would be great. But when you say what was said by, who was that person that said that? Was that Sean Hannity? No, it wasn't Sean Hannity. It was somebody else. One of the conservatives made said that if Donald Trump chose Nikki Haley, I tell you that Dick Morris made that statement. Shame on you. I can tell you right now, Nikki Haley would not be on that ticket. I'm surprised. Dick Morris is pretty good in terms of his analysis, but he's way off the mark here. Now those persons that are running against him would be on that would be the vice president. But Nikki Haley has been very, very bad in terms of where she's coming from, because when Trump left office, she was talking about how they had all fallen, made a mistake by following him, and so on and so forth, showing that she's an opportunist that's trying to back out of her. She's a part of the administration of Donald Trump, accepted the United Nations ambassadorship. And then to disavow that later and turn on Trump as she did. I'm surprised that Dick Morris said that, but she will not be close to being his running mate. That's not going to happen. You can take that one to the bank. Not so many of the others possibly, in terms of, I don't know what will happen with Candace Owens. I don't know what happened with Marjorie Taylor Greene and Carrie Lake. Those are three major contenders. I don't think he can run with another a white male, and I certainly don't think Scott of South Carolina. You can forget that. A lot of hot air coming out of his mouth, but he's not going to be on that ticket. Maybe he thought he could run for president, then he would get the VP because of any kind of acknowledgement of his votes out there, and so on and so forth. Anyway, the main point I'm trying to make here today is we summarize and close out the program here, and that is that the Supreme Court got it right. Jack Smith was smacked down by the court in a rare 9-0 verdict of the court, and that was the court saying clear as it can be said, don't even come here with that. And I hope it's a premature of what the court will say in terms of when it gets to the court about these appeals that Trump will be making about these trials that this man is on, because it should never happen in the first place. I'm saying that because the Constitution does not allow it. If people understood that in Washington, it would not be going on right now. Got to get out of here. Until next time, I want you to follow your dream. If you don't follow your dream, you'll never know what's on the other side of the rainbow.